Very good evening, everyone. We welcome you to our Legal English webinar series. And today we're going to speak about contracts again. And the topic of our webinar tonight is contract breach and remedies in contract law. So we have wonderful Daniel Capretti, who is going to lead this webinar. And we are going to discuss enormous amount of our interesting things, vocabulary, some cases from contract law. If you would like to write any questions or if you would like to ask any questions, please do write them in comments in our YouTube. So you are very welcome to do it. So, and I will look at them, and when the time comes, I will ask Daniel these questions. If you want to answer the questions, because there will be questions to you as to our participants, you can do these. There are two options how you can do this. Either you can also write in comments on our YouTube channel. You need to be subscribed for this to our YouTube channel, or there is a link at the very top of the comments, and it was also sent to you as participants, where you can join the interactive presentation that Daniel has, and you can answer the questions right in this presentation, and only Daniel will see your answers. So you have got two options. So now we're done with the logistics and technicalities, and Daniel, we're extremely happy to see you tonight, and the floor is yours.
Good evening, Sophia, and welcome to all my fellow legal eagles from Russia. Have you heard this expression before, legal eagles?
Honestly, I've seen this. Well, we will ask the audience. Speaking about me, I know the expression legal beagle. There is a guy in Brazil who has legal English classes, and he's called legal beagle. So it's another story. So as I understand that there is some link to the legal eagle. So why this term?
Yes. So a legal eagle is a person who is very keen on law and lawyering. And I think it came about in the 80s, where there was a lot more in the early 90s in America, when there was a lot more interest in law and law programs. There was a big program called LA Law. And, all of the best lawyers on that, they were called legal eagles. Okay, so I know from last week, we have many legal eagles in this group who want to talk about very fascinating and complex contract issues. And that's what we're going to do tonight. So we are continuing our study of contracts, and now we're looking at breach and remedies. So, Sophia, would some of our audience, would they be comfortable with these words, breach and remedies, or should I explain a bit further?
I think the word remedy always causes the confusion.
Yeah, because remedy is you're sick and you take a remedy. And what I love about this word is that it has been adapted for contract law, or actually applied to contract law. So a remedy is, how do we make the person who has suffered from the contract breach well again, or whole again? So it is like almost taking a remedy to make that contract good, or the contractee or the contractor well. And we will look at different types of breach and different types of remedies today.
Super.
But before we do, a thank you to Sophia and our reload, Jennifer. These are the ladies that have made this possible. And this is now the fourth series. And is it the fourth series, or is it, there have been more? Fifth?
The fifth, yes. We have the anniversary, sort of.
Okay, so it's the fifth, and this is my second time around. So thank you, thank you, thank you. And now it's that time. So I love it when I get to see all the words that you already know about contract breach and remedies. So can you please type them into the YouTube? You can type them into my presentation. I see a number of you have signed on. So if you type and then you press send on the bottom right, I will get to view your contributions. Please do so. Because last week we had a very general what words are related to contracts. This is something a little bit more specific here, breach and remedies. And some of the terminology is very complex, multi-syllabic words. So I'm curious to see what you know already. Sophia, do we see anything coming up in the chat on YouTube?
Yes, but it takes some time because
Okay.
sometimes there is a small delay on YouTube, like about 5-10 seconds. So we'll get the comments. And I just wanted to remind once again for those who joined us, so that you can write your answers either in comments on YouTube, or you can write your comments directly in the interactive presentation. So then you will see your answers, and you may do it right through the link that you received as the participants, or you can see the link to it in the comments on YouTube. It's attached to the comments on the very top of our chat. So, and I have started to get some answers. So it's Daniel, it's me or you first?
Let's see. Why don't you go first? I think I'm still waiting. Oh, I have breach and I have the word violation. I like that word. I like that word. Because you violate rights. I have damages, obviously. Penalty, that's also a good one. What's happening at your end, Sophia?
Oh, there is quite a lot, honestly. So I think there is also violation, failure to fulfill obligations, compensation, damages, specific performance and injunction from Ivan, from Anna liability rule, from Marusia monetary damages, punitive damages, from Ilya claim for breach of contract, notice, compensation, from Vladimir penalty, liquidated damages, and the losses from Anastasia.
Okay, so there's some sophisticated terms coming out of there. Liquidated damages, specific performance. We're going to have an interesting discussion about punitive damages. I can guarantee you that. And what were some of the others? Yeah, so a very nice preview, actually, of what we will be looking at this evening. Let me just have one more check of what's coming from me. See if there's anything else that has been added. Oh, I see something. Let's see what it is. Do you have any more, Sophia?
Yes, there are some fines and charges.
Okay.
So a lot. So
yeah, I see the word injunction. That was the one that I didn't mention. That was, yeah, injunction is also a very nice word that we can work into the contract, the discussion of contracts. So let's move on. So thank you for generating all that wonderful vocabulary. Let's put it into a context. Okay, this is my favorite part of the webinar, where I get to learn about how contracts operate in Russia. And I'm wondering, legal eagles out there, can you tell me about breach in Russia? What are the rules concerning a contract breach? And if somebody does breach a contract, what are typical remedies? So please, you can. This is a YouTube, so this is something that you should be writing in. Those of you on YouTube, write in some, some legal principles. I'm assuming, Sophia, is it correct that all of this law is dealt with in the civil code of Russia?
Mostly, yes. Mostly, yes. So
is there anything that isn't in the civil code that has to be
applied, yes, to these? Let's ask our
specialist.
Yes, our specialist. I like this word. Yes, legal eagles, because I do have my answers, but I want the audience to participate. So, and once again, so the question is, so what are the remedies for contract breach under Russian law, like any typical, so in general, so how we would describe the situation, what can be done in order to protect the rights of the injured party if there is a breach under a contract?
And also, what type of behavior constitutes a breach under the Russian code?
So that is very specific. So we're just waiting for the answers. I think it will take some time because
Okay,
there's going
yes.
to be pretty
I'm
long
not
ones.
asking you easy questions. Based on the participation that we had last week, or 2 weeks ago, I'm raising my game. I'm raising my game because I expect great things from all of the brain power that we have with us this evening.
Okay, so there are already answers coming up related to the what regulates the breach. Basically, as Ivan says, it is regulated in the civil code or by the civil code of the Russian Federation. So, and what is interesting that breach of contract depends on the type of contract, and usually the remedies will be written within the article of the civil code that is related to a specific type of contract. So contract for services, for example, and there will be the remedies listed over there, what can be done about it. So delivery of goods, that's another type of contract. So, and if we speak about what, there were some other answers. Anna says that loss of profit and real damage. So what we call in Russia. So, and Anastasia says that it's just breach would be, or the consequences, termination of the contract.
Okay.
So, and there is one more answer from Ivan. If the breach consequented in damages, then you go for damages.
Okay.
So, and Riley says compensation of damages mostly for the business-to-business contracts. If speaking about business-to-client contracts, for example, specific performance. Raphael says mainly those principles and provisions are enshrined in the civil code. There are chapters in it, each devoted to the specific contract, but it's not exhaustive.
Okay.
So,
wow. Thank you
everyone.
My Russian contract legal primer. Obviously, the biggest difference between contracts in a civil law system and a common law system is that in common law, a contract is a contract. The law is not really going to distinguish between types of contracts, with a proviso that consumer law, that is now a subset of law, and there were certain regulations that specifically regulate contracts between a business and consumer. And there was somebody who referred to a similar phenomenon in Russian law. But we don't have this is what regulates a service contract. This is what regulates an employment contract. This is what regulates a goods contract. It's a contract is a contract. So that's a major difference. And all of that said, contracts, especially with regard to breach and remedies, this is an area of the common law in which there is a lot of court-made law and litigation. So the principles that are now enshrined, I like that word, whoever used it, that's a very good word, into contract law, were built up by many years of cases. And again, as I said, in the first year of law school, every law student has to take a year of contracts. That is non-negotiable. And they will study the major cases involving breach and remedies. And these principles will be enshrined in the Chitty-on contracts, which some of you know, and also the second restatement of contracts. So it's a very, that you can't go to a code for our law in this particular case. So there are some significant differences. However, some of the other principles that you were talking about sound very similar, in terms of damages, like, for example, loss of profit, that could possibly be a damage in terms of contracts. Okay, let's move on. So let's just look at the basic definition of what a breach of contract amounts to in common law. And fundamentally, a party breaches when that person fails to perform its promised obligations. Sophia, are there any words in this definition that we should have a discussion about?
No, I don't think so. So it's okay.
Okay. And the one thing that you have to make a distinction here is material breach and a minor or an immaterial breach. Are these new concepts?
Well, so I have a big trust into our audience, and I know a lot of students who have studied and they are quite excellent. So, but maybe for someone it needs to be explained why this material breach is called material breach. So, and what are the consequences? So, or what is the essence of it?
Okay, So in terms of material breach, in this case, again, we're taking material and we're giving it one of its other meanings. It's not material as in clothing material. Material is a synonym for major. And I believe someone, when they were talking about the principles of Russian contract law, they said something similar, that a material breach will invalidate the contract. So if I fail to perform my promised obligations, the other party is not obligated because I have materially breached the contract. Now, there is discussion about what is a material breach versus what is an immaterial breach. For example, okay, if I had a contract with a painter to paint my flat, and I said to the painter, I want you to paint it white, and that painter painted it black. That may be material breach. But what if the painter painted it off-white? So just a little, white with maybe a little bit of gray in it. That may be an immaterial breach. And if it's an immaterial breach, I am still obligated to pay the contractor. So there has been litigation on this aspect of whether the breach is material or immaterial. If it's material, no more obligations. But if it's immaterial, the other party still must perform. It must pay the money. I must pay the money in this case if my walls are off-white, because the breach was a small one. I'm wondering, do we have something similar in Russian contract law?
You are like, you are reading our minds, because there is Lily who just wrote that there is a similar division in Russian law.
Okay. And I think this all makes sense, because a lot of contract law is, it's based on mostly business principles and what makes sense in terms of, keeping a business and the consumer going to the business. And so that, I think this all makes things work much easier in life if you have this concept of material and immaterial, because we can't break a contract for every immaterial breach. Okay. Now, some other breach of contract terms is we have, and look at that word, anticipatory. Anticipatory. Okay, that's your $5 word for today. That, Sophia, you're shaking your head. Anticipatory. Woo. Okay.
I'm more interested in the word repudiates, because from my experience, this is not that often used in Russia. So it's more an English word. So we would differently express it. Okay.
Repudiates is, again, a great contract word. You repudiate the contract. You say, I am not going to perform my obligations in this contract. And notice here, anticipatory, okay, which comes from the word anticipate, okay, which means before. And sometimes when you have an anticipatory breach, you will not necessarily have damages because the party is saying no before anything has happened.
Can you please give us an example?
Yes, I can.
Yeah.
So I'll give it in consumer law, but I think it's a very easy example. For example, over in the US and the UK, a lot of people order online. They order goods online, and to come to their house. In these cases, for example, I ordered something, and I change my mind 2 hours later, and I see that the seller has not delivered anything yet. Usually, I will be able to rescind or repudiate, cancel my order because the seller has not sent the goods to me as of yet. If the seller has already sent the goods to me, we now have, the seller has performed its obligations, so I'm obligated to perform my obligations. So usually with anticipatory breach, it comes very, very quickly after the actual contract has been made or just prior to the expected performance of the contract.
And the question is, who anticipates then this breach?
It's not necessarily a person anticipating it. It's the action, because we're breaching before there is any exchange of promises or exchange of performing the obligations.
Okay, so it doesn't come from the word like that someone anticipates like the other person might terminate a contract. So it's another story.
It's definitely a different story there. And you can the opposite to anticipatory breach is actual breach. Okay. The party has to perform the contract on June 1st. It has to deliver the cars to the factory, or the cars to the warehouse, and does not. Okay, that is an actual breach. So with these two, it's really a matter of timing.
Okay, and we have got two questions. So one of them is from Shersdorbeck. Is revocation or can revocation be considered the same concept as of anticipatory breach?
Yes and no. So it can be anticipatory. It can be actual. It depends on the time. But that is another really good synonym in terms of repudiate, revoke. These are very, very good synonyms that are often used in contract vocabulary. So I'm very happy to see you using that word.
Okay, so and there is another question from Omar who asks, what it's about immaterial breach. What else do you have to do if there is a case of immaterial breach?
Not necessarily anything. Most of the cases, if we look at material breach, it's most of the cases about this have been deciding whether the case is material or immaterial. And that's where the case law sort of concentrates. What they consider immaterial, usually parties may bargain among themselves as to, oh, I'll give you a discount or something of that respect. So usually if it's immaterial, parties will negotiate something. But there's no standard rule or rule of law. And then you can also have the question, if you have a series of immaterial breaches, when do they become a material breach?
Yes.
So that's also, but again, you have to look at the case law of the jurisdiction to really get a sense of when immaterial becomes material. And but generally material breach, these cases, they just don't go to the court. They're negotiated by the parties themselves.
We have some interesting comment from Ivan, who says that it seems that anticipatory and breach is a very subjective judgment, like at the discretion of the parties.
Yes, it is. Yes, it is. In some cases, again, if we talk about consumer law, and that's a very big thing in the UK and the US, there are specific rules about if you order goods online, we call it a cooling off period. So you have time to change your mind. I don't know if you have this in Russia. So in consumer law, a lot of this has been adapted into the law. But in terms of your normal contractual law, yes, it's very subjective. And again, contract law is a big, is in terms of common law, it's one of the areas in which we have a lot of judge-made law, and you see that subjectivity, that case-by-case basis in a lot of this terminology. So that, yes, that's a very good observation.
And we have a last question, which is actually purely linguistic question.
Okay.
So I received a question in Telegram, on Telegram channel. So what is the difference between obliged and obligated? Because some lawyers would say obliged, and as we can see, you are saying obligated. Is there a difference, American versus British, or there is no difference?
I would say they're synonyms. I would also say obliged is a little bit more old-fashioned.
Okay.
But neither is incorrect. I can't think of a difference that you would, I could have said obliged, but I would find that awkward, because the more common way to phrase such a thing would be to use obligated. So obliged is if you're reading a novel, from 100 years ago, you'd see that word, not necessarily now in common usage today, although it is correct though. So it's not incorrect. So yes. Thank you for your terminology question.
So yeah, well, that's just a question that just jumped from Telegram. So it's kind of interesting because we still see it very often in our contract exercises from a lot of course books. So when we deal with it, so the parties are obliged to deliver the goods by, I don't know, the 5th of April.
But remember, a lot of contracts, pro forma contracts and standard contracts, have antiquated language, outdated language. And there is a movement both in the UK and in the US to try to modernize the language and to create contracts which are in plain English, plain speaking. Now, lawyers, though, love these complex words. So you'll find lots of lawyers making contracts with very we say flowery language with flowers, flowery language, and language also that is not current, that if you were speaking to someone, you really wouldn't use that language. So I know exactly what you mean, those exercises, and those are representative of real contracts too. And they are also representative of a model that maybe worked 50 years ago and it still works. So that's why they're not going in and attacking them with the plain English.
With plain English, yes.
This is better.
Okay. Okay, thank you very much. So then for now, I had some questions, but they disappeared. So I think so maybe they will be rephrased. If we see anything else, I will ask.
We have a lot to get through. Okay, so let's think about anticipatory breach. So my question to you all, if you think about it logically, must there be damages in a case of anticipatory breach? Yes, no, depends.
Okay, I will need some time to learn to pronounce it. So it's the word of the day for me today. Anticipatory bridge.
Yeah.
Okay, so
So
and
let me just give you some key, because I know there are others who will have issues with pronouncing it. So anticipate, okay, anticipate, if the stress is on the second syllable, anticipatory. So remember, sometimes when we add syllables to words, the stress comes on a later syllable. So anticipate, anticipatory.
Yeah, because I have in my mind anticipation. That's already kind of late. So now it jumps to a later syllable.
Yes. Yes.
Okay.
And that's often the case.
And while we're waiting for the others, there's some kind of interesting questions, not questions, like comments from our viewers. So Amar says that we also have the similar expression in Russian. Raphael says, I guess it is our thing of lawyers to make everything complicated so no one can have a clue what we're plotting.
Yes, plotting, that's a very good word, Raphael, plotting.
Okay, so, and there is a question. So while we're waiting for the answers, from Vladimir, who asks, can you recommend, maybe it's time to think probably, or maybe for the next class, any court decision that would reveal the work of the anticipatory breach so that the judge describes in detail of how he or she established these like features of such anticipatory breach? Because I understand that's a difficult concept for us. So maybe for the future, maybe it will take some time.
I'll have to have a think about that. I'll have to have a think about that for the future. Let me make a note about that, because that's a good, and maybe we can work this into a future.
So any court decision webinar that would,
but I would be very interested to see if you can do the research yourself and report it back to us.
Okay, so we have a home task. So, and
homework.
Yes, homework. So we have some answers. So honestly, it's like 90% it depends.
Yeah.
Some would say mostly no. And if it's lost profits, then no, never.
Okay. Okay. Yeah, this one, and I think this goes back to Yvonne's comment. It's a very subjective thing. And I might say anticipatory breach, but if the other party has started performing its obligations, then there would be a case for damages. So I can say anticipatory breach all I want. The court may look at it and say, look, this other party started buying things in order to make the product that you ordered. They hired people to make it. So they've already started to rely on your performing your obligations. So we don't have a case of anticipatory breach. We have a case of actual breach. Okay.
So the answer, the answer here will be, just to clarify. So yes, no, like no, or depends.
Depends.
So depends.
Again, this is something that you have to look at on a case by case basis when we're determining damages.
Thank you.
Usually when the things do go to court, it's because they don't agree. One party will say, oh, anticipatory breach, and then the other party say, no, actual breach. Okay. And if you want to, let's see, I have some links later if you want to read more about all of this terminology and have more explanation. And I will point those out when we get there. Okay, so let's move on to now looking at damages and looking at what the courts, how the courts work and how the courts determine damages. The basic rule for determining expectation damages is we need to put the non-breaching party in as good of a position as if the contract was performed. And this I expected the contract to be performed. It was not performed. I lost money. I had some damages. I had some problems. And now the court is going to it's going to remedy. Okay, it's going to make my contract well again. It's going to make me well again because I've been performing, because I've performed my obligations. And in terms of if we want to put a value on expectation damages, it's what was given and what was promised. So I promised this, I gave that. Here, this space is the damages. And you can see this word expect, expectation. It is what I expected to happen and which did not happen.
Mm-hmm. And we started to have a question on Telegram channel. So the question is that can damages for loss of profit or loss of bargain be a synonym of expectation damages or not?
No, it would be a type of expectation damages. So expectation damages would be the title, and this would be one type of expectation damages. So it would be in the family, but not necessarily a synonym, because they're not equal. Because you can have expectation damages of all different types, and we'll get into those.
And there is another question from Avan. So can they be called these expectation damages like real damages? Or maybe there was a question to the or to comment to the loss of profit. So I didn't get it. So real damages, can we apply also these expression?
It is, but this is the terminology.
So because real damages, it's direct transliteration, basically, sort of, not transliteration, direct translation from Russian language.
Interesting. Yeah, because in English, real and expectation, they don't necessarily have the same meaning or connotation. And this is where it gets really difficult because, translation, you have to have one word that is accurate, but to translate to a different legal system as well as a different language, this gets really complicated. And this is why, there are some words which are constantly misused when they are translated into another language. And this is sometimes why concepts get harder when they're translated, especially in legal English, which I think is one of the most challenging branches of English to study and to master.
Yes. Okay, thank you very much. So for the question, for the answer, and Rafael says that basically expectation damages is so-called umbrella term under which there can be a lot of different types. Yes.
Yeah, I like that umbrella term. Umbrella term. Okay. Oh, we headed to a case. Okay, we're headed to our first case. Okay, which I really enjoyed, and I know Sophia enjoyed last time, dealing with some crazy case law. And I have a very special case for you. I did not study this case in law school, but it is a famous case, and it does have an interesting take on damages. Now, so we're going back, I believe it was 1920s here, and Hawkins' hand was scarred. So I believe he was working. And
he got electrocuted. So there was some yes, so it's a
do you know this case?
Yes, of course, hairy hand case, all of these, yes. So, and I will always confused why it was not under tort law. So okay, let me not spoil the story.
He went to Dr. McGee to fix it. So don't spoil the ending, Sophia. And this doctor promised 100% good hand. And in this particular case, McGee used skin from Hawkins' chest to repair the scar, and the hand did not heal and grew thick hair. And as Sophia said, this is the hairy hand case. Now, I'll tell you right now, Sophia, why the tort claim was dismissed by the court. Because I worked in tort law a million years ago. And the thing about medical negligence, it is very difficult to prove. You have to prove the standard of proof is very high, and this makes sense in common law, because if you didn't have that, you know, each operation that didn't go well, patients would be suing doctors. So I can understand why the tort claim, and you're right, the tort, they did try in terms, they made claims under tort and also under contract law, and the contract law claim is the one that went through the court. The tort claim was dismissed. Okay.
It was always amazing because why? Because actually a boy had like hairs growing on its hand. So that was like not standard for human.
Yes. But I worked on a case where if you saw the surgeon, after the surgeon operated on this woman, you would have been shocked. But because he used the accepted surgical technique, you know, and when you, I don't know what you have in Russia, but in the UK, you sign a waiver when you're operated on, you sign a waiver, you know, to basically accept in gross medical negligence that, you know, you understand the operation may not go as well and may cause problems, So, and even in this case, this woman, her body was mangled, but she did not get the money because the surgeon used an acceptable
like protocol techniques
to operate on her. So that's as aside from torts. But as some of you may remember, my webinar from torts last year, it's also a field that is heavily regulated by judge-made law. So, and sometimes we do claim in both, but they accepted the contract claim, which I find a little bit weird, that contract claim was accepted. However, it does prove useful in terms of damages. Okay. And I'm interested to see, given this definition that we have of expectation damages, what you think the plaintiff should get in this case. Now, I have some what we call red herrings here. I've made this really complicated here. So I'll be very curious as to what our audiences on YouTube, Telegram, and ones that are directly on the presentation, what they are going to answer to this one, because this is not easy. But you all did so well last time. I decided that you wanted a bit of a challenge.
And this is great, yes, because I think our audience is already quite sophisticated, and they have been, you know, we have some participants who have been with us for over all of the 5 series, so they're like trained. So, but we have got 2 questions. First question is, if you could clarify just very briefly, are punitive damages. So like punitive, it comes from like punish?
Yes. Okay, so punitive damages are the opposite of expectation damages. And the idea is we're giving this person extra damages because we want to punish them because they were a very bad person. So we can't say that, you know, he has to just pay for a new hand, for example. We'll say he has to pay for a new hand and then pay $1 million or pounds because this person did something that was really unconscionable. There's that wonderful word, unconscionable, or very, very negative. And we want to make sure that person never does it again. And we want to, in essence, scare people.
So like exemplary damages. So so can we call it also exemplary damages? So like to show everyone that if you do something like this, you would be like
Yes.
punished. So it's an example for the others, like don't go there.
Yes.
So, and there is a second question. So from Omar, what does 100% good hand means
Well, yeah,
in the original?
Yeah, that is an interesting question, because it's a very strange phrasing. And I will also note that this case happened in the 1920s, and this was before tort law and medical negligence law became sophisticated. I would doubt today that anyone would bring a contract claim on that, on this basis. I'm assuming that, again, we have to look at the plain meaning of this idea. And I'm assuming just a normal hand. That would be my assumption, that can do everything that is normal.
Okay. Dear Daniel, we have no answers, but more questions. So, well, we have one suggestion. So as an option, so a new operation to fix the hand from Anna.
Okay.
So, and there are two questions. One is from Marusia. Does it mean that punitive damages are always added to expectation damages and never replace them?
Okay. I'm gonna reserve. That's a great question. I'm gonna talk about it after we get those answers, because again,
Okay.
I put something tricky in there for you. I put something tricky.
So, okay, dear all, we're waiting for your answers. I know it's hard, but we need to work something with. We need something to work with. So, and
I'm looking at my answers. Everybody has been very shy.
Yeah, well, it's a difficult one. So, and we have one more question from Ivan.
Okay. Interesting. Okay, I have some answers, and yeah. Oh, okay. I have everything. I have all of the above. I have a new operation to fix the hand, punitive damages, pain and suffering, a new operation. Okay, so I actually have value of the hand that was promised. I have everybody has chosen something different, which I find fascinating.
Yes. So, So, and Ilya says that pain and suffering and punitive damages. So, some of our participants say that that's a difficult case. So, and there is a question from Ivan: how would you estimate a value of the hand? So, in this situation, that would be difficult.
There would be a table that would say what a hand is worth for an individual, depending on how much longer they had to live. And also, the estimate would be related to whether this person, for example, if this person was a manual laborer and could not do his or her job because of the hand, that would be a higher estimate than someone who might be able to do a job despite having this hand. So this is the judge will determine this based on
circumstances and case law.
All the factors again, and it's going to be case by case basis. Okay. So are we ready for the answer?
Yes.
Okay. First off, this is contract law. In contract law, we do not have pain and suffering, nor do we have punitive damages. These are tort law concepts.
And this is what Ivan basically also added in comments, that in Russia, to prove punitive damages, you have to prove pain and suffering, so they're interconnected. So in some situations,
this is so if Hawkins was claiming under tort, of course he could claim pain and suffering, and of course he could claim punitive damages. Yes, he's not claiming under tort. He's claiming under a contract, and this is where there are different silos in terms of damages. So no pain and suffering, no punitive. We cannot claim for that. Remember, expectation damages. We want to make whole. Okay, we want to make whole. And I will add another factor here, that specific performance is very rare it's a very rare phenomenon in contracts law. Most often, it's going to be money. And so the correct answer is the value of the hand that was promised.
Mm-hmm.
And if you want, and those of you who have the presentation, if you want to click on that little finger, you can read the case itself. Can anybody guess where this case is from? 1929, does anybody know, looking at that site, where that would be from?
Mm-hmm. We'll just wait for the answers, yes. Mm-hmm. Okay. So, and so once again, the answer here would be not all of the above, but sorry, I was reading the
Yes, no worries. The value of the hand that was promised.
Okay. Okay.
That is the expectation damage.
Mm-hmm. And speaking about the case, Marusia and Daria say New Hampshire.
That's correct. Yes.
Mm-hmm.
And probably that A means appellate division. So I believe this was the appellate division ruling in this one, but you can look at the case itself and check out which of the New Hampshire courts, whether it was the trial court or an appellate court, making the final decision on this one. Okay, let's move on. Yes, and it was the hairy hand case. And I do want to, in this respect, not only is this case a famous one for law students, it's also famous for the paper chase. Now, I'm very curious, Sophia, are Russians aware of this thing called the paper chase?
Yes. So, yes, because we have a lot of lawyers who love watching the, well, nowadays, mostly the series, Suits, Boston Legal, Good Wife, and so on. But some love the kind of movies from the 70s and 80s, because some of them are pretty famous, especially if they were related to John Grisham and so on and so forth. So,
okay.
Yeah.
So some of you might have seen this. This reminds me of when I went to law school. This was the classic law school education. You have the professor, asking questions. And I have a clip to a YouTube that talks about the Socratic method, which is the method that most law students, when they go to class, this is the method that is used, where the lecturer will ask the students questions about the case and get them to explain the case as well as explain the concepts of the law. And I found this type of education is very valuable for sharpening your mind and also for understanding how the legal system works. So, law can be very boring. This is maybe a way to liven it up and to see how lawyers in America operate and how they were schooled. I'm sure it's very different in Russia. Or maybe not. Maybe it's the same. Maybe it's very similar in law school.
I think it always depends on the teacher.
Yes. Okay. So let's now, when we talk about remedies to breach, compensatory damages are generally what is given, money. Okay. And the different types of compensatory damages are general damages, which are direct damages, consequential damages, which are the results somewhere, for example, loss of profit, and then reliance damages. And these were this is what comes into questions of anticipatory breach. So I have been spending money to perform my obligations on this contract because I am relying on the other to perform. And notice here I have $3 signs because these are the reward is always 99% of the time monetary. So there are ways to determine what the monetary value is of each of these different types of damages.
I have a question.
Yeah.
So from Telegram, what is the difference between reliance damages and expectation damages? Because in brackets, as I assume, you have this expecting, and someone got confused.
So they're different. They're different. Expectation damages is a general concept. Okay. The idea of when we determine damages, we want to make the other party whole again. Reliance damages are a subset of compensatory damages. So there are two different concepts here. But with reliance damages, I want you to think about the idea. I didn't want to repeat the word rely or reliance. I'm relying on the other party to do their part of the contract, so I start doing my part of the contract.
Mm-hmm. We had some case, I remember, it was in Moscow, if I'm not mistaken. So can we call, if I may say just a couple of words, so maybe it will be reliance damages in this situation. There was a case that some company wanted to buy, let's imagine a business center or something like this. And they entered into negotiation. So, and the lawyers started to draft documents. There were a lot of work hours spent. And then the prospective party, I don't remember, seller or buyer, withdrew from the contract. So, from the negotiation. So they almost signed this contract. So the other party sued the one who left the negotiation process for the money that they have spent on the preparation, on the paperwork, and so on and so forth. And I remember that it was translated into English as reliance damages. So they sort of relied on the other parties. They expected them to enter into a contract. So can we say that this is reliance damages?
Yes.
So because remember, it was thank you very much. Yes, Ashan, that was the story about them. Mm-hmm.
Okay, let's look at another case, which I think you probably don't know. And this is a tricky case. Again, I'm not throwing you softballs tonight. I'm throwing you hard balls because I see there's a hunger and a great deal of knowledge amongst our viewing public. So in this case, again, we're going back to the 1800s. This case I remember from law school. So this is one of the founding cases. And it's a little bit strange, this case, because the judge's ruling is not what you would expect it to be. That's all I'm going to say. Now, so there was a shaft operating Hadley's mill, and it broke. And he sent it to repair. A person called Baxendale delivered the shaft to the repair company, but not on time, causing Hadley to lose business. Okay, lost profits, which we were talking about earlier. Hadley then sued for these profits because the shaft was delivered late. It was delivered late to the repair company, so it came back late. Now, key facts here. The mill could not operate without the shaft. So when this wooden shaft broke, the mill completely shut down. Second key fact, Baxendale did not know the mill could not operate without the shaft. Okay, so, okay. Should Hadley recover the lost profits after the delivery date? This is not easy.
Yes, so Hadley, the owner of the mill, Baxendale is like the courier.
Should he sued? He wants those lost profits. He said, that idiot Baxendale, he was late and I couldn't operate. I've lost orders. I've lost profits. Should he recover. So we have 4 options here. And I'm going to wait and see what we get.
Please don't Google it because it's a very famous case.
Yeah, if you Googled it, you'd have to read it. And
I agree.
It's from 1854, and I guarantee you that English is not easy to read. So probably be best that you just guess on your instincts, and then you can read it. Then you can click on the link and you can read it later. Okay, so there's 2 scenarios. So go ahead. Sorry, Sophia.
No. Just wanted to say there is a video that you can watch. It's like 2 minutes, but I didn't say so. So, and this is very weird case, honestly.
But it's a foundational case, and it also shows you an important principle of common law that, you know, I think in this case, I think it could have gone either way. But
can I ask you a question?
Argued it a certain way. Yes.
Can I ask a question? So it's just a question from me. So is this case, it hasn't been overruled, so it is still in force, if I may say. Okay, because it's like 1854. So
yeah, it's one of these. And notice it's an English case. It's from the court of the Exchequer, okay, an equity court, and this is established one of the fundamental principles of common contracts in common law. So yes.
So we start having some answers.
Okay.
So Lily says no, because Baxendale didn't know. So another of our viewers who is like Правовая беседа says yes, even. So because the second option.
Okay.
So there are no more answers yet.
Yeah, I have a no from Tim. Let's see if I have anybody else on my end who's dared to venture forth.
And while we are waiting, so I have some comment also on these reliance damages. So Marusia says that maybe reliance damages were at play when Musk wanted to pull out of the Twitter deal because the seller didn't threaten to sue Musk if Musk refused to buy. So there's obviously some big case. Okay. And we started to have some answers. So Marusia says the last one, no, because Baxendale didn't know. And Julia says yes. Don't know which one yes, but still yes.
Okay.
So.
Okay. Do we answer or do we wait?
Let's answer because there is obviously a big confusion here and there are so many options. Yes.
Okay. Okay. Now, Judge Danielle, if I were judging this case, okay, I would have said yes, because it is reasonable to assume that lost profits would result from the late delivery of the shaft. I think you can make a direct link between that. The loss of the shaft and the loss of profits, me personally. However, and you can read if you click on the little hand, Baxendale, because he did not know the mill could operate without the shaft, the judge said that he was not liable for the damages.
So no money at all. Like he's not liable for anything. So he's liable for late delivery.
We don't know about, you know, again, this is just about lost profits.
Okay.
He could have sued for other reasons. We don't know. But in terms of lost profits, that there was no claim. So they just that claim was rejected. I don't think this is a great decision. However, if we go back to this idea of consequential damages, it did address this idea of, what are consequential damages, and it established this legal principle. So it is an important case, but my guess would be if it would be decided today, they would probably say, look, Baxendale could reasonably assume that if this delivery is delayed, the Hadley is going to lose some profits. So it's a very strange case, but it's an important one.
And a question. So nowadays, if we apply this to modern life, so if a business is ordering something to be delivered by courier service, and they warn, like, urgently, if you do not deliver it, we might lose a lot of money. In this situation, can this case be applied? Well, I mean, so by knowing that there will be some lost profits, like 100%.
If there is a contract formed. Remember, all of this is based on contract law. So if there is a contract where the other business guarantees delivery, yes, of course, you would be entitled to claim lost profits. But remember, in all of these cases, we must have a contract formed based on the 5 rules that we established in the last webinar. And if you do not have a contract, then there is no obligation. So that would be the preceding, one would precede the other. We have to have that contract, and the contract has to be breached, and then you have the damages.
Okay. This is a little bit horrible, Daniel. So, but this is very, very interesting. So it's such an interesting logic. So over there, sometimes we get it, sometimes it is difficult. So, and I'm afraid that every time we're looking at the hand, which we can use later to click to the link, we might think about a hairy hand, I'm afraid.
Yes.
So
yes.
From now on.
Contract law can be ugly. Contract law can be ugly. Yes. Not as ugly as tort law, but in this case, it was. And again, the case itself is important because it established an important principle. But today, you would never have this sort of scenario in contract law. It just wouldn't happen. You would sue in tort. If you sued at all. And again, in this case, I would take the idea that, or I would advocate the idea that Baxendale could have reasonably assumed that there would be lost profits. I mean, the judge did say, if Hadley had told Baxendale, look, my mill has shut down now, I cannot do anything without this shaft, so get it to the repair company as quickly as possible. Then Hadley could have had his lost profits.
Okay, thank you very much. So, and we have got several questions.
Okay.
So first of all, the question from Anastasia: can the parties limit the damages by types that may be claimed in case of the breach of the contract?
Well, that is very anticipatory of you, because, and I don't remember, somebody when we were talking about the different types of damages in the beginning, somebody mentioned this term liquidated damages, and to provide some certainty between the parties, contracts will often specify what happens when one or other party breaches the contract. Okay, and these are called liquidated damages. the convenience of it is it's very clear in black and white what's going to happen, and you don't have to go to court. So most contracts will say, for example, if the wheels are delivered late, then the buyer will be compensated with da 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 da. That is really, the answer that you were talking about. That parties now, they don't want to have this uncertainty, so they will specify it in the contract. And again, though, this shows how much in the common law system the parties have a power to define the terms of their contracts.
So can we say that these damages can be also called sort of stipulated, so the parties predetermine them? So
Yes.
It's kind of weird phrase, liquidated, so it confuses, I think,
it's a
people.
very strange phrase. I don't, we have the word liquidity, talk about how liquid are you, how easily can you access cash. This is like a sort of you may have come across this term when you were studying banking or finance law. But it is a very strange term. I agree.
Okay.
I agree. But that's the term.
Okay, so that is the answer to Anastasia's question. Can the parties limit the damages by liquidated damages, specifically specifying them? And what about the specific performance?
Okay. So as I said, this is a very rarely used type of remedy. The case where you would most often see it is in the case of a piece of art. For example, I paid you $1 million and you are supposed to deliver the piece of art. You don't deliver the piece of art. The judge can say, I demand that you deliver this piece of art.
Because it is unique, sort of, yes.
There's one other case. Sometimes when there is a contract for a famous performer to perform and they decide they don't want to, a judge could order specific performance. It has happened in the past. But these are very, very rare cases. And again, in most cases, we would have common law damages in terms of money.
And we have another question from our Telegram channel. So does English or American common law have the concept of penalty? So because in Russia, the word penalty is used in many, many situations when we speak about sort of liquidation damages concept, sort of. So, but it would be just called penalty. So basically the other party is sort of fined. So for non-performance, and then like every day they would say like every day you were supposed to like pay 0.5% of the price. So if you do not perform, so something like this. So is the word penalty like used in relation to damages? As I understand, that was the question.
Yeah, that's a very good question. And I know the word penalty, penal, always causes a lot of problems.
Yeah.
Because somehow in all of languages, there seems to be different concepts of, and again, going from common to civil law, there's something different. So
yes, because they are very similar, but we are not we cannot translate Russian penalty as liquidated damages.
Exactly. So what you have to think about here is penalty and penal. These are, in one respect, criminal law terms. Okay, so we have the penal system.
Yes.
And if you are driving on the wrong side of the road or you violate a traffic code, you get a penalty. Okay, so there's a criminal law aspect to it. Now, in terms of tort law, you have punitive damages. Okay, the penalty, you did a very bad thing, and we're going to give you even more damages. Because you were a bad person. We're going to give you an extra $1 million because you pay the plaintiff an extra $1 million. In terms of contracts, yes, you can refer to penalties in the contract, but it's not used as much because contracts it's a civil law, and if you made a bad contract, unless it was an unconscionable contract, when we were talking about you charge a 99-year-old lady $1 million to paint her house, unless it was an unconscionable contract, the government is not going to impose a penalty on you. Because contracts is generally, except again in consumer law, is an agreement between two parties, okay, private parties, and it is a branch of civil law. So I would not overuse the concept of penalty, because for us, it has this idea of the state is getting involved. And our contracts, generally, the state is not involved. This idea of freedom of contract is fundamental to the common law system.
Okay, thank you very much. That was excellent to understand. Very clear. Okay, and we have one more question, which is very specific. I'm not sure, actually, I don't get it right, probably. So there is a question from Shehzad Beg. Can one make the relation between the losses and the non-conformity to quality?
Okay, I see what you mean. It's going to have to depend on whether it was a material breach or an immaterial breach.
I think some of us didn't understand the question.
Okay.
And we just understood the
what
answer.
I'm understanding, someone has produced something and the quality was not up to the standard of what was expected by the buyer, for example. That would be a question of material or immaterial breach. So you would have to look at the language of the contract and decide whether this product not being up to a quality, whether that was a material breach or an immaterial breach.
Yeah, so, and Shehzad Beg said that it was related to the case, I think, that we were discussing. So, but thank you so much, so Daniel. So, and thank you very much. And there is last one, if you have time for a question. So there is a question about the word forfeit. So, like, is the word forfeit used in contracts sort of related to the word fine, penalty? So, because he says that forfeit shall be recognized as the sum of money defined by the law by the agreement, which the debtor is obliged to pay to the creditor in case of non-performance. So, I would use the word forfeit as a verb, basically. So if you pay, for example, some advance payment, a deposit, you might lose it or forfeit. If
you forfeit rights, you forfeit rights. Not used necessarily as much. Again, you may though see this in a older contract with that, again, the flowery language that and sort of would be characteristic of a contract written 50 or 100 years ago.
Okay, so all right, so it may be used, but it's like very, very archaic or arcane word. Okay, thank you so much.
Okay, so we're headed into the home stretch today. From fantastic observations as always. As I said, I have a link to the Cornell Legal Institute, and they have all sorts of nice definitions, links to various laws, links to the restatement, so you can check out more on contract law vocabulary there. Sometimes they even do refer to cases. And now I would like to find out what your most interesting word was. And we have lots of vocabulary in this session. So I expect lots of lots of different choices.
Yes. So everyone, so the question is, the request is to, if you could please write your most memorable word from the session. And if you have any questions left, so please, you are very welcome to also submit them so we can answer. So if we're not able to answer all of them, so they can be like moved to the other. So webinar. And while we're waiting for your answers, I just wanted to also remind you that after some time, we prepare the translation of the most important terms, usually roughly about 30 from the presentation from English into Russian. They also are, you can see the links to them on the official page, website page of the project. So next to the program, so there will be a link to the video, link to the presentation, which is uploaded and which was graciously given to us by Daniel. So you have actually the presentations. You can watch, download, and there is also the link to the translation of the vocabulary. So, and even after our webinars are over, someday they will be over, the series. So there is access to them that is forever on, I hope, on our web page. So, and there will be a difficult task, Daniel, this time to translate all of this.
Good luck. Whoever's doing that translation,
it's
good
me.
luck.
And I'm like already sitting and thinking, oh my goodness, Lord. So
Okay, contracts law is really, it's very term heavy. And, as you can see, anticipatory.
oh,
These
that's, yes.
huge words. And
Yes,
actually,
and all of this.
that seems the word that, according to the people who are getting back to me, everybody loves that word, anticipatory. Yes.
So I have immaterial damages, liquidated damages,
Good.
and repudiate. And I think most of the people would also choose anticipatory. So, and repudiation. So repudiation, anticipatory, and liquidated damages. These are the hits of the today class.
These are the hits of the contract session. Okay, so if there are no more questions, let's look ahead. So we've finished our contracts, our formal
basics
study of contracts themselves. And now we're going to be moving on to a very specific type of contract, which is a property contract. Some of you, you had, again, your minds blown when we had the session about buying a lease in the UK, and property is one of my favorite topics. So now we're going to be switching to looking at contracts in property, which are obviously very important. On our next session in March already, we'll look at a rental agreement, and then in the session following, we'll then look at a sales agreement and what type of clauses that you would have and what type of principles are assumed in such agreements. So a wider contracts, obviously, they permeate every aspect of law, and especially in property law.
Okay, thank you so much. We're so looking forward to it. And also what we are planning to do, so we've already had 2 sessions on contracts, and we'll start revising the vocabulary step by step. So there will be mostly in our Telegram channel. So we would be trying to put every day or every other day some terminology from the previous sessions. And as you reminded me, Daniel, right now, so that we had the property sessions with you in general, speaking about property. So I might also add some of the vocabulary to our Telegram channel so we can discuss from the previous series with you. So there will be some preparation, probably some of the basic terms. So we look at them. So we'll see. So we'll see how it goes. So, and it will be interesting for us because we already have the bank of the words. There's going to be more. This is pretty cool. So thank you so much. Thank you. And we would like to thank our viewers. Thank you. So that was extremely interesting, difficult, but very, very interesting.
It is interesting. It's difficult, but it is necessary. I can't imagine what it would be to translate a contract in Russian to a contract in English. And with the idea of having this, you have to translate the systems. It just sounds like a nightmare. And I'm glad that I'm not fluent in Russian, so nobody will ever ask me to do something like that, because that just is. And this is also a problem in German and Italian, all of these civil law, all of the civil law countries too, and to make this translation. And we, as legal English, who operate in the legal English world, teachers, lawyers, we have a very grave obligation to get it right, because obviously if you don't get it right, people could lose business and it could create a lot of problems.
Yes, and we are so grateful to you because you help us understand much better the words, the concepts. And it's such a valuable knowledge. Thank you so much, because this is really, you are the source, the beacon of light for us in this. So, and we're so looking forward to the next sessions. And thank you so much for these ones. So thank you. Thank you. Thank you. So, and everyone, we're saying goodbye to you, and see you in 2 weeks. Already in March, spring is coming. So bye-bye, everyone. And thank you. Bye-bye. Thanks a lot.